立法會主席。
The President.
呢項辯論嘅主題係有關
The debate of this debate is about the retirement ages of judicial and officers and judges. As in the case of the Inland Revenue Amendment Bill, I have been very relaxed in allowing the members to speak on different issues. And then I noticed that Mr. Kenneth Leung did digress, and I asked him to come back to the subject. I have been adopting the same standard. Whenever I detect digressions, I would ask the member to return to the subject at hand. Mr. Kenneth Leung said I will use 2 yardsticks. I think that's not in line with the facts, and also that's an offensive. I asked Mr. Leung to withdraw that accusation. He refused. I ask him again now.
Statement doesn't exist because I was asking you a question, and if you have clarified that it's not, then I think it's fine. I was asking a question whether there is any there exists 2 yardsticks. So that statement does not exist, and I'm turning it into a question. It was a question, Mr. President.
我想你清楚講你係會收。
I would like you to state clearly that you're going to recheck it.
Does not exist. Formally declare that statement does not exist because I was wondering whether there were 2 yardsticks. And if that statement does not exist, then I do not need any more clarification because that was not a statement. That was not a statement, and that was not an allegation. That was a question asking you, Mr. President.
梁啟章議員，請你繼續。
Mr. Kenneth Leung, please continue.
To the point of increasing supply of lawyers, because it is relevant to this bill, because the whole purpose of this bill is to increase the supply of good quality judges to the bench. And I have previously mentioned that certain protectionism must be relaxed, and I talk about this law students and also the other hurdle in which I would like to see some relaxation is about registered foreign lawyers. Now, if we increase the supply of lawyers from qualified common law jurisdictions, one way or the other, that would in the medium run or in the long run lure more qualified lawyers to sit on the bench. That is another formula which I think the government need to think about it hard and persuade the 2 professional bodies to consider whether either the acceptance of students with PCL or qualifying as Hong Kong practicing solicitors or barristers should be adjusted, the criteria. These are very important long-term goals which the government should be aware of. And the other scenario I'm aware of is the quality of advocacy in this city. And this also have a direct bearing on people becoming interested in the work of a court. Now, I should emphasize that the mooting training in our law schools are not adequate, are not sufficient. And I would also appreciate the chance of sending more law students from the 3 universities to go on foreign trips to have work experience in common law courts in other jurisdictions. In those jurisdictions from where we recruit these judges, Canada, New Zealand, and Australia. And only by stimulating the interest of those students in advocacy and court work would we be able to secure a constant supply of good quality lawyers and hence good quality judges if the judiciary is going to recruit these students when they qualified. And the third point I would like the government to consider, apart from raising the retirement age, is that have you ever considered requiring law students to go through a stint of training with the courts in Hong Kong. Now, in many civil law jurisdictions, including France or Germany, they do require law students, apart from serving their training with a practicing lawyer, a solicitor, or they don't have a separate branch. They call it advocates in France. They would also require the students to follow a period, 1 year or 2, in the court to be an assistant to a judge or be assistant judge. But of course, the common law system training is very different from the civil law jurisdiction training. And if we are going to take this route, then I think there need to be a very thorough consultation with the 2 professional bodies and also the 3 universities which are offering the qualifying courses. And so I reiterate, I totally support the resumption of the second reading of the bill, and I also urge the government to formalize more measures to increase the long-term supply of good quality lawyers and attract the lawyers to be serving on the bench. Thank you.
吳永嘉議員。
多謝主席，我發言係支持。
Mr. Jimmy, I speak in support of the Judicial Office's Extension of Retirement Age Amendment Bill 2019. The bill has to do with tackling the lack of JJO manpower. As you know, the unrest from the extradition law amendment saga has yet to end it, and thousands of people were arrested, and such massive arrest figures were unprecedented. If the riots continue, there will be more arrests and not less. Since the 2014 Occupy movement, the main perpetrators were prosecuted only in March 2017, and judgments were only laid down by the courts recently. And the unrest now far exceeds the Occupy movement in scale, and a lot of court resources are required, including the demand for JJOs. This is unprecedented. This highlights the lack of JJO manpower and the need to extend their retirement ages. And this proposal is certainly much needed and important. With the extension of the retirement age of judges mean that they can shoulder the normal workload, many people point out that in terms of remuneration, serving as a judge cannot compare to serving in private practice, but the workload is equally heavy. And as such, a lot of legal professionals are dissuaded from joining the bench. And many people are concerned about the workload of judges who agreed to extend their terms. And the administration indicated that for retired judges who are re-engaged as deputy judges, the workload would be comparable to ordinary judges. In terms, according to some reports, for example, a report in January this year, in the opening address delivered by the Chief Justice, Mr. Jeffrey Ma, to mark the opening of the year, we saw that a number of judges have shown fatigue during the occasion, and many judges face a heavy workload. Of course, I do not want to discriminate in terms of age, but when a person is 75 or 76 years old, we have to pay more attention to the potential issue of workload or fatigue. For a criminal case involving many plaintiffs, the judges would have to examine all the relevant evidence before the opening of the case, and they would have to read many files, and they have to work from 9 to 5 every day for up to 100 days. I'm sure the president would understand their plight, because there is no deputy right now at LegCo. They would have to consider the submissions of many different barristers or solicitors before the judges have to write their judgments, amounting to dozens or hundreds of pages. The workload is very heavy, and this might impose stress on certain judges who are getting on. So we must be very careful in deciding the extension of retirement ages. Apart from laying down judgments, the judges might have to take up management duties as well. So we might need to review the workload of judges in which the terms have been extended. For example, do we need to hire extra staff to deal with the administrative work? And in the paper provided by the Judiciary Administration, the retirement ages of UK and New Zealand judges is 70, and Canada 65, and in Singapore 65. In Australia, for the federal courts, the retirement age is 70. For the family courts, 65. So different courts would adopt different retirement ages based on workload. Extension of retirement age is not a long-term solution. Even if the terms of judges are constantly extended, there would be this would only delay the shortage of judicial manpower. We should enhance training of JJOs, and judicial staff should provide more support to the judges. And in face of the long-standing shortage of JJO manpower, we should try to attract more new blood by adjusting the workload and remuneration levels, and we should enhance the training on JJOs and refine their career ladders in order to appeal to more judicial practitioners. We should also refine the recruitment methods. So is there a real need to constantly extend the retirement age of judges? And I'd like to share my views. According to the High Court Ordinance Pt4, Section 9 brackets 1A and 9 brackets 2A, any lawyers who have practiced for 10 years or more can be hired as a judge of the High Court, but the main recruitment targets are barristers at the moment, and as such, very few judges were hired from the legal profession. The former chairman of the Law Society, Mr. C, pointed out that many law firms allow their lawyers to take up roles such as deputy registrars at the district court, and they would also be candidates for deputy judges. And I'd like to share experience from other countries. In the United States, the senators, federal judges, and legal professionals, state governors, the Barrister Association, etc., they would all be consulted, and the Bar Association would also consult the community, even though the process would be very long-winding. And this might deter experienced candidates from making self-recommendations or volunteering. And the process might jeopardize judicial independence. But this is an example of the checks and balances between the three powers. And in the UK, the candidates for the courts must first be subject to the deputy or the registrars of the Court of Appeal, courts of the High Court, the chairman of the Law Association, and this consultation system is not systematic, but more details of the candidates can be obtained so that the future judges hired can make better judgments. Now, back to the Hong Kong situation. The appointment of judges involve consultation of the legal profession, but some people would criticize the process of lacking transparency. I suggest the judiciary to clearly explain the criteria and processes of appointing judges in order to enhance transparency. That way, more legal professionals can grasp the information, and more experienced lawyers should be invited to join the bench in order to tackle the manpower shortage. President, artificial intelligence is a global trend. According to a report on the 10 jobs that are most unlikely to be replaced by AI, the top of the list is lawyers, because lawyers must be possessed with debating skills, and so far it's not possible for AI to acquire such skills. AI can help process data, but they cannot help persuade judges and the jury, and we can see that judges are indispensable, and that's why we must cherish our JJO resources. I speak in support of the bill. Thank you.
Mr. Paul Chair, I would like to thank Mr. Michael Look for giving me the floor before him, as I will be otherwise engaged in the afternoon. Well, Mr. Ng referred to AI judges. Let me respond to this point. I don't think I would quite subscribe to his view. That is, in our future world, judges cannot be replaced by AIs. Well, for solicitors, I think we are standing at a high risk. Of course, when it comes to litigation, AI cannot replace us. But then in terms of research work, etc., I think the AI can save a lot of time on the part of the judiciary as well as the lawyers. Well, I don't speak from a script. I would like to speak to the point. Of course, I will firmly support the bill. Of course, I would say that I agree with the saying that when you get old, you become wiser. For judges, when they reach the age of 70, of course, don't ask them to run in a race, but then they will be well equipped to apply the social values when they judge a case, and they know human nature, they know what's happening in the world. So they will have a very careful and detailed analysis of the details of a case. Probably what we have to watch out is that, of course, our physical strength may deteriorate. For those judges who have been exercising their minds all the time, I don't have any doubt. I would say that some judges may get tired more easily. President, of course, from time to time, you may sort of switch off. But for judges, they can't, because they have to listen to each and every word of the witnesses. Otherwise, that would have a bearing on the final judgment of the case. Well, President, according to our understanding, well, some judges have been mandated to retire, and it has an impact on the manpower. So it is a sensible development to extend the retirement age. But of course, in our society, we have taken issues with retirement ages. For bus drivers, on average, they are at the age of 65 is an aging career, and new blood cannot be attracted to become bus drivers. For judges, I think there are certain features concerning this particular profession. I haven't been a judge, but then in my profession, I have come into contact with many judges, and because I've been working as a solicitor and previously as a barrister. Well, in the past, I used to be asked by my priest in the school to become a priest. I think not everybody can become a priest. For somebody who is a football player, he may not be interested in becoming the referee. And then there are people who would like to have a lot of freedom. When I was a sort of a trainee, I worked endlessly for many hours, but when I felt like it, maybe I just went on a cruise. If you become a full-time judge, you cannot have that sort of freedom. Of course, they are entitled to quite a number of days off. I think this sort of restriction has a bearing on people not becoming interested in becoming judges. And of course, there's the dollar sign. For a quality barrister, I'm sure he makes a lot more money than judges at the middle level or at the high court levels. Well, there are people who want to join the bench because when you are a good player, a good actor, you will want to become a director. So when you are very good at the job of a barrister, you may then want to obey the call of your vocation, or when you get older, you don't want to have so many challenges and you don't want to exert yourself too much. You may want to join the bench because it's quieter, and then you can plan your life in a more structured way. So that's the thinking of many people, and in particular in the UK, lawyers enjoying high status in the society would want to join the bench because of the very respected status of judges. Well, this is different in Hong Kong. Like lawyers, I think judges have also got their status being challenged. For we legislative councillors, well, sometimes people have looked down upon us. In the court, whenever it is announced that the judge is coming in, everybody will stand up. We used to have the same convention here. Nowadays, people don't have that sort of courtesy. I think if we start showing disrespect here in this chamber, then it is quite like showing disrespect to the judiciary in a courtroom. Mr. President, I think we need to understand the extension of the retirement age of JJOs so as to address the problem of shortage of manpower and as well as the lack of experience of the part of the incumbents. Well, I've mentioned the possible factors. First, the dollar sign, the social status, the pace of your career, and of course, the lack of a revolving door is also an issue. There are pros and cons. If you become a judge at the district court level or above, you are prohibited from rejoining the private practice so as to avoid the perception or actual conflict of interest. Therefore, many people have been deterred from going down a road of no return. So there are pros and cons. We have to weigh the pros and cons. we always want to have judges who are independent, and therefore we don't want to have a revolving door. Probably we can revisit this topic further down the road. Let me talk about possible solutions other than extending the retirement age in the light of the very severe shortage of manpower. Mr. President, of course, a very significant factor is that many people think that judges no longer enjoy high status and can judge the case independently. Politics has crept into the judiciary. So many people have been discouraged. In fact, there are people who want to join the bench because they want to have a quiet time. But I have to warn you that we can never have an independent judiciary. Well, it is only human nature to understand this point. Well, you may very well think that we are going after the logic, we go after the facts when you are in the legal profession, either as a lawyer or as a judge. But in fact, studies have found that, in fact, we don't start with our mind. We start with our heart. The wiser, the cleverer the judge and the lawyer, the harder they will try to disguise what they think deep down in their heart. Well, President, you have had the experience of having to rule on our remarks, etc. So extending the retirement age won't just have all the advantages of merits. There are also other disadvantages, like blockage of junior officers. I don't think it is very serious in Hong Kong, though I would say that in Hong Kong it is bottom heavy. We have too many people at the junior level, but fewer or not enough judges at the top. People of my age have become High Court judges or even judges at a higher level. I have already mentioned that if you look at the pay or the remuneration, I think in this way we can compare lawmakers with the GJOs. Some lawmakers become lawmakers because of the remuneration, but most of us would like to sort of be true to our conviction and our faith. Now for judiciary, I don't think the pay of the GJOs isn't that attractive. Those more senior judges will get a high level of pay. I think it's a matter of values. When you become a judge in the age bracket of 60s, 70s, etc., you become very conservative. But usually people are conservative when they take up the job as a judge. So usually they want to maintain law and order, etc. So if the age of the judges is sort of getting higher and higher, we have to discuss and find out whether it is actually good for society as a whole, because they will become very conservative. And then politicization of our legal system. It isn't something new, and as Mr. Ng has said, for the senior judicial appointments in overseas countries, usually they will also require the endorsement of the legislature. Well, you would all recall the case of Brett Kavanaugh. I think he was examined, and I think the saga was really eye-opening. Many judges don't want to sort of see this happening to us, but then it is a development that we have to watch. Mr. Kenneth Leung referred to a report of the Foreign Affairs Committee of the UK. They were sort of saying bluntly that they didn't want the UK judges to come to Hong Kong to join our courts because they don't want British judges being seen to be part of a system that would harm the people. Sort of, they don't want to be complicit. They don't want to have anything to do with the judiciary of Hong Kong. I think this is lopsided, it is inappropriate, it is unfair. This is because we always have a sound system. Other than the factors that I referred to a moment ago, I think in Hong Kong, our judiciary has enjoyed a very good reputation. And among the common law jurisdictions, I think our judgments have been cited many times. Say, for example, the case I was involved in relation to Edward Zhang, it has always been quoted by other lawyers in other jurisdictions. So we do have a very high standard of work. Now, according to the basic law, if you turn to Article 82, we may invite judges from other common law jurisdictions to sit on the Court of Final Appeal as required. That's the key word. It doesn't mean that we have to do it no matter what. But then we made a wrong start, and then our CJ in each and every case of the CFA is invited non-permanent judges from other common law jurisdictions to sit on the court, sit on the bench. Well, there are pros and cons, and of course, we are sharing the common law jurisdictions. But the merit is that we are having a judge who hasn't got much to do with Hong Kong to come here to rule our cases, like their views on sexual orientation, views on welfare. In Chinese societies, we emphasize the groups rather than the individuals. This will hinder our development. Say, for example, there was a ruling on the welfare entitlements of new arrivals, as well as torture claims. For someone who is unfamiliar with the case of Hong Kong, will have a different view from us. And then in the UK, if they don't like the ruling of a particular case, they can always revise the law. But in Hong Kong, we haven't got the same happening. It's not easy to make a change. So when the CFA hands down a judgment that deviates from our values, then it makes life very difficult for us. And torture claims is an outstanding or a very significant example. So for the CFA rulings, as Mrs. Regina Yip has said, it appears that the judges are making laws on our behalf, and there are serious consequences, and it will be difficult to overturn them. I think we need to address this problem.
Mr. Tommy Zhang. Thank you, President. President, the Liberal Party supports this bill in principle, and that is we would like to accept the judiciary's proposal to extend the retirement ages of judges and judicial officers. The bill would retain the two-tier system for retirement, and that is CFI and above would have a higher retirement age for their judges, up to 70. As for those courts under CFI, the retirement age will be 65 after the amendment. So there are two different retirement ages depending on the judicial offices. This is mainly to address the manpower problems of CFI courts and other and above, without affecting the courts below the CFI level, and also not to in order not to affect the promotion ladder or advancement of junior judicial officers. And therefore, on one hand, the judiciary would like to have more new blood, and at the same time, the two-tier retirement age system will be retained. We support this in the Liberal Party. As at the 31st of March this year, among the 280 posts in the establishment, there are more than 60 vacancies. And there are 15 vacancies in the master's office. Only 2 have been filled. At the district council, there were 9 vacancies which have not been filled. Although they can use a redeployment for the relevant court duties, but then it's not desirable. In 2018, the review report on judicial remuneration, it is pointed out that the main reason for wastage is retirement, and retirement may pose a challenge to judicial manpower. We must face up to this problem. During the scrutiny of the bill, the administration provided figures, and we know the wastage situation well. It is expected that for judges and judicial officers in 2018-2019, there will be 8 who were left, or 4.9% of the total establishment. In 2019-2020, the number will go up to 14, or the 8.5% of the establishment. As for 2020-2021, it will be slightly drop back to 12. Again, it's still 7.3% of the current strength of judges and judicial officers. And if we look at the retirement of judges in 2018, 20 to 2019, 6 judges and judicial officers will reach a retirement age, and 32 JJOs will reach retirement age in 3 years' time. And that is the 1st of 2019 to the 31st of March 2020. Although they can seek extension of retirement, but depending on the judicial office one holds, it will be subject to a case-by-case approval. And they will only be extended to serve until 65, 70, or 71, as the case may be. In 2014, the judiciary conducted a review on retirement ages of JJO. A consultant was engaged with a questionnaire survey conducted to collect views of JJOs and stakeholder groups, and most responded by saying that they agree to the extension of retirement ages. In summing up the consultation findings and in the light of the recommendation of the consultant, the judiciary has made a number of proposals. 2 years ago, the reports were submitted to the judiciary, and that's why we have now this bill. President Sang, judiciary system is very important to Hong Kong when we need to have sufficient manpower in different courts to ensure the efficiency and effective discharge of judicial functions. We have seen a number of social conflicts in recent months, and as a result, there will be a large number of cases to be handled. So manpower problem has become more acute. Many professional sectors are facing manpower shortage problems. The judiciary is particularly hard hit because qualified candidates to be appointed as CFI judges or judges of higher courts is not easy to find. The number of suitable candidates is very limited. As a result, recruitment of CFI judges and above have been fraught with difficulties. So for judges at CFI or higher level, which will be expanded from 65 to 70, that would help us retain experienced judges, and also to attract experienced and qualified practitioners in the legal professions to join the judiciary. I understand that JJOs, upon reaching the statutory retirement ages, may still seek to extend their retirement age. For CFI and the Court of Appeal, they can be the retirement ages can be extended 2 times, but by not more than 2 years by 3 times, as was other judges. They can be extended once or more for more than one occasion, provided that the total length will not exceed 5 years. And usually the extended period is just 1, 2, or 3 years. For CA and CFI judges, they can be on a discretionary basis extend their service to 76, 75 respectively, and the maximum retirement age of CFI can be 70 after extension. But discretionary extension is subject to health assessment to ensure that they remain in good healthy conditions to serve as judges. If suddenly their health conditions deteriorate, which may affect their ability to serve as judges, then whether they have reached the retirement ages or not, the judiciary can look into these cases individually. If it's found that the JJOs are unable to discharge their duties, they can retire on health grounds without having to wait until the end of the extended period. According to the Judicial Officers Recommendation Committee's policy, extension of a retirement age is considered exceptional and will only be approved once if some factors are satisfied. First, operational needs of the judiciary, including the need for continuity. Second, the extension of a retirement age will not affect the advancement of junior judicial officers. The Liberal Party is of the view that although the retirement ages of the different JJOs will be extended under the bill, that the discretion, the flexibility of granting further extension should be retained. It's not uncommon. For example, when we look at the CFA and past cases, since the CFA was established in 1997, there was only one occasion of extension in 1998, having regard to the special situations then. At that time, the CFA was still a new court, and the Chief Justice considered the interests of the judiciary and also the continuity of the newly established CFA, and therefore it was recommended that the CFA judge in question should have his retirement age extended. Hong Kong is famous for long lifespan. Many retirees are still in good health and can still work, and many of them are willing to serve our community. So if we allow them to continue to contribute to our community, it's a win-win situation. The Liberal Party also thinks that we cannot really address the manpower shortage of the judiciary simply by extending retirement ages. There should be more effective measures implemented, such as improving the remuneration and conditions of engagement of judges and judicial officers. And also, we should find ways to retain the existing JJOs. There was a benchmark review in 2015 on remuneration and conditions of service, and the Commission recommended 6% upward adjustment. That's the suggestion from JSCS. As for CFI, the judges they recommended increase of 4%, and JSCS also make recommendations on housing benefits, medical, dental benefits, local education allowance, and passage allowance, and other suggestions to make improvements to the package. The relevant improvements were implemented in April, in September 2016 and April 2017, but that's already 2 years ago. The Liberal Party is of the view that we should continue to monitor the wastage of JJOs and conduct a timely review of their condition of service to attract more legal practitioners to become JJOs. President, the Liberal Party it has always been in favor of extending retirement ages, not just in the case of JJOs. For example, in the consultation for extending the retirement ages of civil servants, the Liberal Party did point out that we are facing an aging population in Hong Kong, and therefore we need to make sure that there will be sufficient manpower. And we pointed out that the government should expedite the review on civil service retirement age. And after a few years, last year, it was announced that those who are employed after the 1st of June 2015 and also for those who are employed from the 4th of June to May of 2015 will have the option to retire at 65. As for discipline services, 60. They can retire at 60. So as to comprehensively resolve the problems of retirement. Although the progress has been slower than we want, but on the whole, we welcome these measures. All in all, the workforce in Hong Kong is expected to be very tense in 2030. We are going to face a shrinking workforce in Hong Kong. We need to retain our talent, professional people, as well as judges. So I submit, the meeting is now suspended until 2:30 p.m.